thought Pennsylvania had done away with common law marriage.
That's interesting. It has. Common law marriage was abolished in 2005, but any common law marriages entered into prior to that date are grandfathered in.
Okay.
So what's interesting is you have these same-sex couples that had commitment ceremonies in the 1970s and the 1980s and the 1990s, possibly where even one of the partners has died, and they've paid a significant amount of inheritance taxes because their marriage wasn't recognized. It was a personal commitment they made to one another.
But not legally recognized yet.
Right. So those couples have been able to file for recognition of a retroactive common law marriage.
And get a tax refund?
And getting tax refunds back on the inheritance taxes they paid, which in many cases were very significant because it's 15%, regardless of the size of the estate, for non-family members as far as the inheritance tax in Pennsylvania. So that's been a huge benefit to especially very long-term same-sex couples. Because it was abolished in 2005, it really only affects couples that entered into marriages with one another before that date.
What are some of the other issues that are still being ironed out? We'll take Pennsylvania, which is our home state and we know well. What are some of the issues post the U.S. Supreme Court decision on marriage equality that still need to be ironed out as this continues to be implemented?
I think the biggest issue in Pennsylvania and really across the country is the issue of legal parentage of children that are born to married couples. So traditionally in the law, there's been this idea of a marital presumption of paternity, that any child born to a married woman, that her husband is the, quote, father of that child. And that's the way that the case law has all played out, is that it's a biological presumption that her husband must be the father. And the policy behind that was to kind of preserve the family unit and try to not have other parties come in and try to challenge, some other guy come in and say, no, I'm really the father. But a lot of those presumptions are falling to the wayside as DNA testing has become much more prevalent in society, where people are actually able to prove their legal parentage physically through biology.
So, but the presumption means that in the absence of any actual evidence to the contrary, that father is the father as long as they're legally married at the time the baby is born.
If they're married. And that presumption, there's times where that presumption can be rebutted. One of the times is if the relationship is no longer intact, then there's no longer a public policy to try to preserve a family unit if it's no longer a family unit. So when a couple is separating, a lot of times that's when someone else can come in and try to use DNA evidence to prove their parentage, or someone can try to challenge or try to walk away from their parentage based on a lack of a genetic connection.
So how has that played out in same-sex couples then?
Well, I think it's played out because there isn't a statute, and it's all played out through case law, through this common law. And most of the common law that's developed has all exclusively been in the context of opposite-sex married couples, typically in the context of like paternity fraud and affairs. And there have not been any cases thus far, even dealing with assisted reproduction, children who are conceived through assisted reproduction. So you have a body of case law that's developed factually very differently from the context of a couple where from the very beginning they know they're conceiving a child together where someone is not genetically related, that they both went into the arrangement knowing that. So then the question is later on, can the person who's genetically connected use that against the other person and say, you're not a genetic parent, you have no rights, you cannot see this child, you have no custodial rights, even though your name's on a birth certificate, because we were married at the time the child was born, we're no longer an intact family and you're not genetically related, therefore you're not a parent because there's nothing in the law that says that you are.
That's really surprising because assisted reproduction technology has been around for a long time. I don't know exactly how long, but it seems like it's been around for decades.
Absolutely.
In one form or another. So it's surprising that there isn't some reference from heterosexual couples conceiving through some form of assisted reproduction.
There is case law, but there's not case law in the context of the marital presumption.
Okay.
So there's case law. There's some case law that's developed in Pennsylvania around surrogacy that's actually very positive towards assisted reproduction in Pennsylvania. There's case law that says There's a case called JF versus DB where a heterosexual couple had worked with a gestational carrier in Pennsylvania who agreed to carry triplets on behalf of this couple.
Wow.
And she gave birth to the triplets, and she decided at that point she didn't like the intended parents. She didn't like how they were behaving during the time of the birth, and she decided she was going to take those babies home from the hospital and parent them. And it was a very long custody battle between the genetic father and herself, because she claimed that she was the legal mother because she gave birth, even though she was not genetically related to those children. And she had entered into a contract with them that she was going to just be the gestational carrier. And the court in Pennsylvania, as a superior court, held that she was not a parent because she was not genetically related, and that she was not even a party who was in loco parentis. So she didn't even have the right to file for custody at all. She had no legal standing because the genetic father had never given her permission to be the caregiver of those children post-birth.